that you just heard. I'm not sure if we want to do them together, Your Honor, or do them separately.
Got to do them separately.
Yes, sir.
Fully raise your right hand, please. Let us be. Let you be placed under oath.
Do you solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth, so help you God?
I do.
All right. I've been handed a document indicating that he is going to be entering a plea of no contest to child endangerment, Class B felony. It'll be amended to aggravated assault, a Class C felony. He would receive a sentence of 3 years probation and would be required, in order to pay the court costs, and be required to continue to comply with the Department of Children's Services requirement, 0 tolerance for any drug screens. State your full name for the record.
Charles Cleveland Bully.
Mr. Pulley, you're here today on a felony indictment. You've heard me go over what the agreement is with you, that your lawyers worked out with you, but do you understand what you're charged with? And have you and Mr. Taylor had a chance to talk over the range of punishments you're facing, as well as any possible offenses you might have? Well, it's indicated that you want to enter a plea of no contest or nolo contendere. Do you understand that simply means you understand what the state's evidence is? You're not going to admit you did anything, but you're not going to contest what the state's evidence is when the state tells me what their facts are. You understand that? And that will be used to find you guilty according to this agreement. I've got to have you answer verbally on the record, please.
Yes, sir.
Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
You understand that if you went to trial, you'd have the right to have a lawyer and have one appointed if you cannot afford your own. And of course, we've done that with the public defender's office. Do you understand that? Do you understand that if you went to trial, you would be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you can be convicted of any crimes?
Yes, sir.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena.
Yes.
You understand that at trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial, you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes.
You understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out.
Yes.
That's going to result in a felony conviction. It's going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you want to waive your right to a trial by entering a plea of no contest according to this agreement?
Yes,
sir. Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No.
You understand I can't accept your plea unless I'm satisfied there's a factual basis for it and that you are in fact guilty.
Yes, sir.
I want you to step aside and let the state come to the podium and tell me what their facts would be at trial.
Your Honor, the state would put on proof that this case actually began on December 30th, 2024. Deputies responded to the home of the defendants here in Houston County for domestic issues. It was noted that there was drug use in the home, so DCS was called in. And then in January of this year, the children did come back. They had been exposed to methamphetamine. Again, since then, defendants have been to treatment. Mr. Pulley is passing all his drug screens. He is working with the court and complying with DCS. The state would not have made this offer if those changes had not been made.
All right, Mr. Pulley, I'm not asking you to agree with those facts, but do you understand that's what the state's evidence would be if you went to trial?
Yes, Your Honor.
You still wish to plead no contest?
Yes, Your Honor.
Are you satisfied with your attorney's services?
I am.
You feel like Mr. Taylor's done a good job of representing you competently?
Yes.
Mr. Taylor, do you know of any reason we should not end this plea?
No, Judge.
Then Charles Pulley and docket number 2025 CR 2B, upon your plea of no contest to count 1, which is a single count indictment, I find you guilty, sentence you, that would be actually amended to an aggravated assault. Find you guilty, sentence you to 3 years, Tennessee Department of Corrections. You ordered to pay the court costs. You're also ordered to continue to comply with DCS requirements, a 0 tolerance for any drug screens. Now, you've heard me fuss at 2 people before you,
Yes,
and I'm going to tell you the same thing. You know, if you love your children, the last thing you would want to do is to expose them to something that's potentially deadly or harmful to them You wouldn't let them play with guns and potentially kill themselves, but exposing them to drugs is basically about the same thing. You're letting them play Russian roulette, so to speak, or you're playing Russian roulette with their lives. So make sure that this is a chance. You understand this is the sole chance you're going to be given to avoid going to prison for 3 years.
Yes, sir.
Is to comply with everything you're supposed to do, stay out of trouble, stay away from the drugs, take care of your children, get back to trying to raise your kids and let them have a parent in their life. I assume you want to be a father.
Oh, absolutely.
So if you want to be a father, you're going to have to try to be there for them and take care of them instead of sitting in prison. So good luck to you. I hope it all works out for you. And if not, I'll see you again and we'll ship you off to prison. Okay.
Thank you, John.
All right. All right, Mr. Johnson has a multi-count indictment. He is, if I'm understanding correctly, going to be entering a plea to count 1, count 4, count 5, count 6, and the remaining charges are being dismissed.
Correct. I believe the only one that's technically being nollied is count 2.
Okay. He is on count 1. He is receiving a sentence of 2 years to serve in the Tennessee Department of Corrections as a range 1 offender. That will be completely suspended in state probation after serving 30 days in custody. Credit for time served. His fines would be waived due to his indigent status. He was ordered to pay the court costs of driver's license suspended for 1 year. Count 4. His sentence would be 2 years to serve Tennessee Department of Corrections as a range 1 offender, suspended in state probation, $50 fine and costs. Concurrently, count 1, count 5, aggravated assault on a law enforcement officer. He would receive a sentence of 5 years to serve in the Department of Corrections as a range 1 offender. That has a 100% release eligibility. It would be suspended, however, in state probation after serving 90 days in custody, waives his fines and costs. It would be concurrent with counts 1 and 4. Count 6, who would receive a sentence of 2 years for vandalism to serve in the Department of Corrections as a range 1 offender, completely suspended state probation, waive the fines and court costs, ordered to pay $1,700 in restitution to Tennessee Highway Patrol, which would be concurrent with counts 1 and 4 and 5. And then you said counts 2 is nollie, but counts 3, 7, 8, 9, and 10.
Correct.
Oh.
Actually, Your Honor, count 2 can be dismissed. I confirm that the person who was driving a stolen vehicle. I confirm that person was made whole in that vehicle, so there's no restitution. She's not work responsible.
All right. So there is restitution, but that's to the Highway Patrol, correct?
That's correct.
Mr. Johnson, raise your right hand. Let's place you under oath.
You solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God.
Thank you. Put your hand down now. State your full name for the record.
Avery Rashawn Johnson.
Mr. Johnson, you're here today on a multi-count indictment. You've heard me go over what the agreement is, but have you seen or been shown a copy of the charges, gone over with your lawyer, and you and Mr. Rudd discussed the range of punishment you're facing as well as any possible defenses you might have? You feel like you understand what you're charged with?
Yes, sir.
You feel like you understand what this agreement is?
Yes, sir.
Do you understand that you have a right to plead not guilty to this charge, all charges, and have a speedy and public trial by jury?
Yes, sir.
You understand that if you went to trial, you'd have the right to have a lawyer, to have one appointed if you cannot afford your own. Do you understand that if you went to trial, you'd be presumed to be innocent until such time, if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
You understand that if you went to trial, you and Mr. Rudd could confront and cross-examine every witness the state called, and you could bring your own witnesses in by using a subpoena.
Yes, sir.
You understand that you would be presumed to be innocent at trial. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
Do you understand that by entering this plea of guilty, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyers worked out. But do you understand that's going to result in a number of convictions, some felonies, some misdemeanors, and those are going to be on your record in the future to make more severe the punishment you receive if you are ever again convicted of a crime.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to waive your right to a trial by entering this plea of guilty according to this agreement? You want to plead guilty according to this agreement, take this deal?
Yes, sir.
All right. Do you understand that if you plead guilty, the court of the state could ask you questions about these offenses? And if you answer these questions under oath on the record in the presence of your lawyer, your answers may later be used against you in a prosecution for perjury if it turns out you were lying under oath.
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
Yes, sir.
You understand? I can't accept your pleas unless I'm satisfied that there is a factual basis for them that you are in fact guilty of these charges.
Yes, sir.
Then are you guilty of these charges that you are charged, that you're pleading to?
Yes, sir.
Tell me what happened. Tell me what happened that led you to be arrested.
Was going to the car here, pick somebody up. And on the way back, I got scared and ran away.
Okay. There was a reckless endangerment. Was that because you were driving really fast?
Yes, sir.
And then there's a aggravated assault on a police officer, law enforcement officer. What happened with that?
I got scared and that was ran into him.
You ran into him?
Yes, sir.
Okay. And that's where the vandalism also comes from?
Yes, sir.
Okay. State have anything else they want to add in the way of proof of evidence?
There you go.
Are you satisfied with your attorney's services?
Yes, sir.
I feel like Mr. Rudd has done a good job of representing you competently.
Yes, sir.
Mr. Rudd, do you know of any reason he should not enter these pleas? Then Avery Johnson, in docket number 2025 CR 18, upon your plea to count one, I find you guilty, sentence you to 2 years, Tennessee Department of Corrections. That will be suspended to probation after you serve 30 days with credit for time served. Fines and costs are waived. Your license to drive is suspended for 1 year. In count 4, you're found guilty, sentenced to 2 years, Department of Corrections as a range 1 offender, suspended to probation in order to pay a $50 fine and costs, concurrent with count 1. Count 5, you're found guilty of aggravated assault on a law enforcement officer, sentenced to 5 years, Tennessee Department of Corrections, and that will be suspended to state probation after you serve 90 days in custody with credit for time served. Your fines and costs are waived. This will be concurrent with counts 1 and 4. And in count 6, you're found guilty of vandalism, sentenced to 2 years, Tennessee Department of Corrections, suspended to probation after you've, suspended to probation in order to pay court costs. Fines are waived, and you're ordered to pay $1,700 in restitution to Tennessee Highway Patrol. These will all be concurrently. The remaining cases are dismissed. He needs to probably see the probation officer before he exits the building today. So,
Thank you, Your Honor.
thank you.